Hello and welcome to BYJU'S IAS. Welcome to yet another episode of Explained. June 2020, the President of India promulgated 3 farm ordinances. September 2020, the Parliament of India enacted the 3 farm laws, basically replacing the previous ordinances. Farmers, particularly from Punjab and Haryana, have been protesting against the 3 farm laws. This month, the Honorable Supreme Court stayed the implementation of the 3 farm laws, appointed a 4-member committee to mediate between the protesting farmers and the Government of India. But still, the protests continue. The Government of India even offered that we will hold the implementation of the laws for 1.5 years. But the farmers want nothing but the total repeal of the laws. Protests continue. In this session, we will not argue whether these laws are good or bad. Clearly, there are strong arguments both in favor of these laws as well as against these laws. But in this session, we will specifically focus on 2 themes. One, the constitutionality of these laws. Are these laws constitutional? Second, the Supreme Court order staying the implementation of these laws and appointing a 4-member committee to mediate between the protesting farmers and the Government of India. So let's get started, but first up, let me briefly take you through these 3 laws, very briefly, so that we set the context. This is law number 1, and let me try and make it as simple as possible for you to understand. Let's say, for example, I'm a farmer. This is my produce, wheat, paddy. Now I have to sell this produce. What do? I approach the nearby APMC Mandi. There I get in touch with a commission agent, Arthia, and I ask him, get me the best price for this produce. And in these APMC Mandis, this farm produce is auctioned and I get the best price. What do these Arthias get? They get the commission. These Arthias basically ensure that the buyer need not interact with multiple farmers. So this commission agent, this Arthia, is basically a link between the buyer and the farmers. Farmers are happy, they get the best price. There is another way for this farmer to sell this produce. Instead of selling this produce in the APMC Mandi, what I can do, I can also sell this produce outside of the APMC Mandi as well. But for that, I have to pay the fee, I have to pay the tax to the government. APMC Mandi tax is also imposed. There is a third way also in which I can sell my produce. And that is what we call based on minimum support price. It's basically an insurance for me. Even before the sowing season, the government announces the MSP, minimum support price, so that I don't have to worry as a farmer about what is going to be the price in the open market of my farm produce. Regardless of the situation, this MSP, this minimum support price, I will get for my produce if I sell this produce directly to the government. This is how and what was the situation prior to this law. Now what this law has done, it is creating a barrier-free intrastate and interstate trade of farmers' produce. How? Now the farmer, if the farmer wants to sell this farm produce outside of the APMC Mandi as well, no tax, no fee can be imposed, neither by the APMC Mandi nor by the state government. So farmer has a liberty. If you want to sell your produce inside the APMC Mandi, do that. If you want to sell your produce outside of the APMC Mandi as well, please do that. You have the liberty. On top of that, if for example, I belong to APMC Mandi A, prior to this law, I could only sell my produce inside this APMC Mandi A. But now I can sell it in APMC Mandi B. Let's say for example, I'm from Punjab. I can now sell in Haryana APMC Mandi as well. So it's a win-win situation for a farmer. Then why is a farmer protesting, particularly from Punjab and Haryana? Farmer is saying that basically what the government is doing, it is corporatizing agriculture. How? If I am allowed to sell outside of these APMC mandis as well, directly to the corporates, initially I will get the best price. But slowly and steadily, what the government is trying to do, according to the farmers, they want to kill the APMC mandis. So initially we will get the best price from the corporate sector. But once these APMC mandis disappear, then we will be left at the mercy of these corporates and they will exploit us. That is why they want nothing but the total repeal of this law. This is law number 1. Law number 2 basically promotes contract farming. But contract farming is not something new. It was in practice before that as well. But what this law does, it creates a national framework for this contract farming. And what is this contract farming? Let's say, for example, I'm a farmer. I have this piece of land. There is a corporate entity. There is an MNC. There is a food processing industry. They get in touch with me that you have this land. We want potatoes for our chips or for our snacks. So before you sow potatoes, this is the price and we will guarantee you that this is the price that we will pay you. A win-win situation for farmer. That's what the government is claiming. That one, you can sell your produce inside the APMC mandi. You can sell your produce outside of the APMC mandi as well. You can sell your produce in a different state's APMC mandi as well. On top of that, we are providing a national framework for the contract farming. So why are you protesting? The farmers are saying, what if tomorrow these corporates bind us to some illogical terms and conditions which we are not in a position to understand? If this is a win-win situation for us, why is it that you are not writing in the law, mentioning in the law that these multinational companies, these corporates, these food processing industries, they will pay us above the MSP? They will not force us to enter into a contract and sell our farm produce below the MSP. The government is saying that we are willing to mention MSP in the law as well, giving you a written assurance regarding the MSP, but the farmers want the total repeal of the laws. The third law, Essential Commodities Amendment Act of 2020. And what this Amendment Act basically does, it removes cereals, pulses, oilseeds, edible oils, onions, potatoes from the list of essential commodities. What will happen because of that? Let's say, for example, these are onions. The price of onions in the open market right now is 20 rupees a kg. Big traders, what they will do? They will buy this onion produce in bulk and they will start hoarding. When they will start hoarding, they are creating artificial scarcity of onions in the market. Ultimately, what will happen? The demand is more, the supply is less. The price of onions will increase. And slowly and steadily, these traders, they will push these onion produce in the market and they will get the best price. That is why there is an Essential Commodities Act, which means if tomorrow onions are declared as essential commodities, you cannot hoard onions beyond a specific limit. If you do that, if you hold onions beyond a specific limit, you will have to sell it in the open market. But even if you are reluctant to sell it, raids will be conducted. Your produce will be confiscated and sold in the open market, auctioned in the open market. But the government is saying this Essential Commodities Act, basically it prevents the entry of the private sector. They might want to set up an established supply chain in the agricultural sector. But this Essential Commodities Act acts as an impediment. Why would a private sector invest millions of rupees in setting up cold chain, in setting up supply chain? Because tomorrow, when they hoard the farm produce inside these cold storages, the government will say, no, you can't hoard, you can't stockpile the essential commodities beyond a specific limit, so sell it. That is why the government says, let's promote private investment in the agriculture and let's remove onions, cereals, pulses, edible oils, potatoes from the list of essential commodities. This is the brief about what are these three farm laws, so that you get an idea how these farm laws are affecting the farmers or affecting the larger public. Now let's look at the first theme. Let's look at whether these farm laws are constitutional or unconstitutional. Ours is a federal democracy. We believe in federal constitution. And in federal constitution, there is something called distribution of powers. There is something called union list, state list, and concurrent list. What is union list? Any item that is placed in the union list, who has the power to make laws? Only the parliament. For example, banking, insurance, citizenship, extradition, external affairs, defense, for example. On all these items, who has the power to make laws? Only the parliament. Then there is something called state list. In normal circumstances, the state legislature has the power to make laws on any item mentioned in the state list. For example, law and order, land, gambling, agriculture. Agriculture is a state subject. Then we have concurrent list. Any item that is mentioned in the concurrent list, both parliament as well as the state legislature, they will have the power to make laws. For example, marriage and divorce, criminal procedure, civil procedure, education. Both parliament as well as state legislatures have the power to make laws. But if there is a conflict, there is a law passed by the state legislature on an item mentioned in the concurrent list, this law is in contradiction to the parliamentary law. Which law will prevail? It's the parliamentary law which will prevail. But there is another alternative. Let's say, for example, there is one state legislature which is making a law on criminal procedure, which comes under concurrent list. Can this law prevail in that state? Yes. If this law is given permission by the President of India. That means the state legislature passes a law on any item mentioned in the concurrent list. Can this law, because it is in conflict with the parliamentary law, can this law prevail in the state? Yes. Only if this law is being given assent by the President of India, by the central government. This is the wide distribution of powers. And when we look at the state list, agriculture is in the state list. So how can Parliament make a law on agriculture? Not just agriculture, trade and commerce within the state is under state list. Not just that, production, supply and distribution of goods is in the state list. Not just that, markets and fairs is part of the state list. So in distribution of powers, we have agriculture part of state list. We have trade and commerce within the state, which is part of the state list. We have production, supply and distribution of goods, which is part of the state list. We have markets and fairs, which is part of the state list. So how can Parliament make a law on agriculture? How can Parliament facilitate contract farming within a state? How can Parliament dictate to a state that farmers in your state, they can sell in one APMC mandi and in another APMC mandi? That's the domain of the legislature of that state. That's the legitimate prerogative of the state legislature. Looking at this context, intrastate marketing in agriculture, that means within a state, if agricultural marketing is to be practiced, this was always considered to be within the legitimate domain of the state legislature. So are these laws unconstitutional because the Parliament is legislating on a state list? Perhaps no. Why? Because this time the government of India, the Parliament resorted to entry 33 of list 3. What is entry 33 of list 3? List 3 basically concurrent list. What is this concurrent list? Constitution says in the distribution of powers that trade and commerce in what? In foodstuff. Production, supply and distribution of foodstuffs. It is where? It is in concurrent list. Isn't there a contradiction? On one hand, we are saying production, supply, distribution of goods is in state list. On the other side, we are also saying that trade and commerce is also within the state list. And at the same time, we are saying it is also in concurrent list. Because the Constitution has made it abundantly clear that this entry 26, this entry 27 is subject to entry 33 of the concurrent list. Which means, yes, state legislatures, you have the power to make a law regulating trade and commerce within your state, subject to the law passed by the Parliament. Yes, you have the power to regulate production, supply and distribution of goods within your state, but subject to the law passed by the parliament. So based on this ground, maybe these laws are not unconstitutional, because in the distribution of powers, it is mentioned in the concurrent list that this power is given to the parliament as well. But if we dig a slightly deeper, we look at something else. This entry 33 of concurrent list, it was not originally part of the Constitution. How? It was inserted into the Constitution by 3rd Constitutional Amendment Act 1954. How? There is something called Article 369 of the Constitution. What is Article 369? Temporary power is given to the Parliament. Dear Parliament, you have a temporary power. What is this temporary power? That you can make laws on certain items mentioned in the state list as if these items are in concurrent list. So what are you saying? Dear Parliament, you have a power, but this is a temporary power. This power is only for a period of 5 years. For a period of 5 years, you have a temporary power that you can make laws on certain items mentioned in the state list as if these items are in concurrent list. Production, supply, distribution of goods is in state list, but you can make law but for 5 years. Similarly, distribution of goods. Similarly, trade and commerce within the state. That is part of state list, but dear Parliament, you can make a law, but only for a period of 5 years. But what was temporary for a period of 5 years, that was made permanent forever because of this Constitutional Amendment Act 1954. When this bill was introduced in the Parliament, at that point in time, this bill was sent to the Joint Committee of the Parliament. There were at least 7 members of this Joint Committee who protested. They said, don't do that. Why? Because this is not within your domain. Original Constitution said that trade and commerce within the state, production, distribution and supply of goods within the state, this is the power available to the Parliament only temporarily, only for a period of 5 years. So Constitution did not envisage that this temporary power should be given to the Parliament forever. Constitution did not envisage that this temporary power will become permanent forever. Don't do that. Because if you do that, you are going to convert our federal constitution into a unitary constitution. Ashok Mehta, for example, what he said? He said, today, dear Parliament, if you want to take control over trade and commerce within the state, tomorrow what you will ask? You will ask that cropping pattern will also come under the parliamentary jurisdiction. Tomorrow agriculture will also come into your jurisdiction, which means you will make states redundant in India. Somebody else, Mr. K.K. Basu, he said, because of these changes, you are basically converting our federal constitution into unitary one, and you're reducing the states to the level of the municipalities. Please don't do that. So all those dissenters in 1954 who pleaded before the Parliament, please don't convert a temporary provision into a permanent one, because you are encroaching within the legitimate domain of the states. Those dissenters unfortunately have been proven right today, because the Parliament has used this entry 33 of concurrent list and has passed laws of far-reaching consequences for the farmers of this country. So this is how we can look at one aspect of the constitutionality of these farm laws. But there is another aspect. Lack of consultation, no select committee route. There has to be consultation with the stakeholders before the Parliament can enact a law, before the government can bring in legislations in the Parliament. The government says that we consulted a large section of the population, including the farmers, but then an RTI application was filed. RTI application asked the government, can you please show us the level of consultation that you have had with various stakeholders? Can you show us those documents, what was agreed upon, what was not agreed upon? The RTI application was replied to, and the government said, we have no record of the consultation, which basically means Perhaps there was no consultation. At the same time, the opposition inside the parliament asked the government, can you please refer these bills to the select committee of the parliament? Let's discuss, let's debate. Select committee route is always a better route so that we can iron out the differences, so that we can consult the farmers. But nothing happened and these bills were passed. But even then, there is another strong argument against the constitutionality of these laws. And what is that argument? The voting on the farm bills, particularly in Rajya Sabha, it was not done in accordance with the rules of the House. How? There is a bill. This bill needs to be voted upon. And once this bill is voted upon, it becomes a law after President signs this bill. But on this particular bill, voting has to take place. Constitution says under Article 100 that any question or all questions at any sitting of the House shall be determined by the majority of the votes of the members present and voting. That means if this is a bill, please vote on these bills. Get the simple majority in the parliament and the bill is passed. In this case, what has happened? The bills were passed in the parliament, particularly in Rajya Sabha, by voice vote, despite the fact that the opposition asked for the division of votes. What is the difference between voice vote and division of votes? Let me make it simple for you. Here is a bill. This bill needs to be voted upon. That means on this particular bill, we should have a simple majority. Because without simple majority, Article 100 of the Constitution says, without majority of the members of the parliament, this bill cannot be passed. That means we need simple majority. But how does a presiding officer satisfy himself, speaker satisfy himself, that on this particular bill I have the majority? Normally he goes for voice vote. What is this voice vote? Dear members of the Rajya Sabha, this bill is presented before you. Those who are in favor of this bill may say A. Those who are against this bill may say no. I think the A's have it, the A's have it, the bill is passed. This is voice vote. Voice vote is not mentioned in the Constitution. Constitution does not recognize voice vote. Even then, voice vote is followed. Why? Because there is always an assumption that this is a bill which is brought by the government. The government has the majority. So when government has the majority, the presiding officer is putting this bill through voice vote, the bill is passed. But the rules say, if any one member of the parliament would object to this voice vote and would ask for the division of vote, it is mandatory for the presiding officer to go for division. What is this division? If voice vote is over, now the member is asking for division. Now there will be real voting on the floor of Rajya Sabha, so that people can get an idea how many people are in favor of this law, how many people are against this law. The members in Rajya Sabha, they asked for the division of votes. The presiding officer said that there is disorder in Rajya Sabha. When there is disorder in Rajya Sabha, I am going to say that this bill is passed by the voice vote. That means through voice vote, the bill was passed. This was not passed by the division of votes. On this ground, the bills are unconstitutional. But is it so? Maybe not. Why? Because there is Article 122 of the Constitution. Article 122 says the validity of any proceedings in the parliament shall not be called in question on the ground of any alleged irregularity of procedure, which means that judiciary cannot question whether the procedure in the parliament was followed or not. That means judiciary, while looking at the constitutionality of a law, will only look at whether parliament had the competence to pass this law, whether this law violates fundamental rights or is in agreement with the fundamental rights. Judiciary will not say that since parliament did not follow the rules, that is why this bill is unconstitutional or this law is unconstitutional. No, because Article 122 prohibits judiciary from striking down a law merely on this ground that procedure in the parliament was not followed. But there is another argument. In Raja Rampal case 2007, Supreme Court said, we will not get into whether procedure has been followed or not, but on substantive grounds, we can inquire whether the substantive grounds were violated while passing a law, while passing a bill. What is the difference? Tomorrow, courts cannot say that you pass this bill in 1 hour discussion. That is why this bill is unconstitutional. No, that's a procedural ground. Tomorrow, constitutional bill or a normal bill cannot be struck down by the courts on the ground that you did not allow opposition to speak. No, this cannot be the ground. But a violation of the Constitution is not an ordinary procedure. On the ground that Constitution was violated, these farm bills can be struck down. This farm law can be struck down. How? Article 107. Article 107 says, a bill shall not be deemed to have been passed by the Parliament unless and until it has been agreed to by both houses. What does Constitution say? Article 107. A bill is deemed to be passed by the Parliament if it is agreed to by both Lok Sabha as well as Rajya Sabha. Critics say, number one, voice vote is not recognized in the Constitution. Article 100 says that any bill, in order to be passed, should be passed by the majority of the members. That means by simple majority. Since in Rajya Sabha, the bill was passed through voice vote, which is not recognized by the Constitution, there was no division of votes, it means that this bill was not passed in the Rajya Sabha. When this bill was not passed in the Rajya Sabha, that means Article 107 has been violated. Lok Sabha has passed this bill, but not Rajya Sabha. On this ground, these farm laws can be struck down by the courts. This is one theme that we wanted to focus upon, the constitutionality of these laws. So there is one strong argument which believes that these laws are constitutional. Why? Because the Parliament resorted to entry 33 of the concurrent list. You may say that it is wrong to give this much power to the Parliament, but power is given by the Constitution. So power given by the Constitution was used by the Parliament to promulgate these laws. These laws are constitutional. But there are others who say procedure was violated inside the Parliament, not only an ordinary procedure, but Constitution was violated by passing these bills, by passing these laws. So these laws are unconstitutional. And these laws are passed on agriculture, which is a state list. That is why these laws are unconstitutional. That is one theme. Let's look at the second theme. The Supreme Court stayed the implementation of these laws, appointed a 4-member committee to mediate between the protesting farmers and the Government of India. Why? Supreme Court was perhaps right. Supreme Court said, and Supreme Court was unusually harsh on the government, which we don't normally see, but this time the Supreme Court was very harsh on the government. Supreme Court said, you have consulted the farmers after the laws were passed, and now there have been multiple talks between the government and the farmers, the farmer unions, but still there is no resolution of the deadlock. The deadlock persists. That is why we believe that we will stay the implementation of these laws, and we will appoint a technical committee so that this technical committee will mediate between the protesting farmers and the Government of India, so that a congenial atmosphere is created, so that the trust of the farmers is taken into account. Because basically these farm laws, they have widened the trust deficit between the government, between the Parliament and the farmers. So basically it's all about trust. And the Supreme Court said, let's build the trust. Let's bridge this trust deficit. And for that, let's set up this committee. Till that time, we will stay the implementation of these laws. When these talks have failed, there are people who are criticizing the Supreme Court for setting up this committee. They are criticizing the Supreme Court for favoring the government of the day. But perhaps they are wrong. Let's give it to the government. The government has been very flexible in inviting the protesting farmers that please come, let's discuss, let's debate. Look at the number of meetings conducted between the government and the protesting farmers. Even today there was a meeting. So the government has shown, with all credit to the government, a lot of flexibility in dealing with the farmers. But even then, the deadlock persists. In this situation, should Supreme Court act like a mute spectator and not get involved in this? After all, Supreme Court is the guarantor of our fundamental rights, the protector of our constitution, the guardian of our constitution. So what is wrong if the Supreme Court wants to interfere and tries and sees if there is a resolution? Why are you criticizing Supreme Court for this? And this is not the first time that Supreme Court has appointed a committee. When people were protesting in Shaheen Bagh against the Citizenship Amendment Act, a committee was set up by the Supreme Court to talk to the protesters. Close to 2 decades ago, a high-level technical committee of 5 people was set up by the Supreme Court on genetically modified crops, GM crops. So this is not unprecedented on part of the Supreme Court to set up a committee, because Supreme Court earnestly wants a resolution to this dispute. And Supreme Court, there was a petition before the Supreme Court asking the Supreme Court, please evict these farmers. The Supreme Court said no, they have the fundamental right to protest, and their fundamental right to protest must be recognized. So Supreme Court was very flexible in dealing with these protests. So what is wrong if the Supreme Court wants to act like a mediator? But then there is another side of the story, which is highly critical of the Supreme Court. There are broadly 3 sets of petitions before the court, before the Supreme Court. Petition number 1, challenging the constitutional validity of these farm laws. Petition number 2, those who are supporting these farm laws. And it's ironical. If you're supporting these laws, the laws have been passed, why approach the court? But one set of petition challenging the constitutional validity of these laws, another set of petition supporting these laws. There is third set of petition by some of the residents in Delhi, those who believe that because the highways have been blocked by the protesting farmers, it is causing inconvenience. So that is why there is a petition before the court that please evict these farmers, in line with your Shaheen Bagh judgment. Because last year Supreme Court said, if you want to protest, please do that. But protest at a designated place so that you do not inconvenience the larger public. Residents in Delhi are saying that these protesting farmers, they are causing inconvenience. They are blocking important highways. And that is why, in line and in light of your Shaheen Bagh judgment, please evict these protesting farmers. So these are the 3 broad set of petitions filed before the court. None of these petitions is asking the Supreme Court to mediate. So why is Supreme Court mediating? That's problem number 1. The Supreme Court is not deciding whether these laws are constitutional or unconstitutional. The Supreme Court is staying the implementation of these laws, setting up a 4-member committee to mediate. But dear Supreme Court, who asked you to mediate? Either declare that these laws are constitutional or declare that these laws are unconstitutional. Why mediate? Something else. There are those who are praising the farmers, criticizing the Supreme Court. Farmers are right in not meeting the members of this committee. And by not meeting the members of this committee, the farmers have reaffirmed a basic principle of democratic accountability and responsible governance. There is lack of trust between the government and the farmers. So this is a political problem. Let politics resolve this conflict between the farmers and the government. Supreme Court, please stay away from this. This is a dispute between the government and its people. The government is accountable to the people. Supreme Court, please stay away from this. There are some who are criticizing the Supreme Court, saying Supreme Court is not pronouncing whether these laws are constitutional or not, and it is entering into political and administrative management. Dear Supreme Court, there are lakhs of cases pending in your court. Please solve them and don't enter into mediation. This is a matter of dispute between the government and its people and the farmers. Let politics take the call. Don't interfere. If you want to decide upon the constitutionality of these laws, please do that, but don't mediate. Something else. Farmers have basically objected to being forced into binding mediation, and they are suspecting the composition of such a committee. How? Look at the irony, according to critics. They say that Supreme Court wants to act like a mediator, appoint a committee so that this committee can mediate between the protesting farmers and the government of India. But by doing that, it is violating the first principle of mediation. And what is that first principle of mediation? It should be agreeable to both the parties. The farmers did not approach the court. The farmers did not ask the Supreme Court to please set up a committee which can mediate between us and the government. So this mediation is not acceptable to farmers. Why are you forcing them into mediation? You are violating the first principle of mediation. Problem number 2, they suspect the composition of this committee. 4 members were appointed by the Supreme Court to this committee, and all these 4 members, they have praised the farm laws. Almost all these 4 members, they have written articles favoring these farm laws. So if the composition of the committee, if the members of the committee are in favor of these farm laws against which the farmers are protesting, why have such a committee? On top of that, when the first meeting was held between the protesting farmers and the government of India, the government of India told the farmers, let's set up a committee and all your concerns, all your problems, let's ask that technical committee to look into. In the first meeting itself, the farmers protested, objected and refused to have a committee. And the same thing is now done by the Supreme Court. What farmers rejected in their first meeting, today the Supreme Court is asking, let's have a committee and this committee will mediate between the farmers and the government of India. Something else, stay on the implementation of these farm laws. And this is where it becomes very, very interesting. The Supreme Court has said, we are not staying the law. We are not staying the law. What we are doing? We are staying the implementation of the law. P. Sainath, one of the brilliant minds on agriculture, rural development, he says this is like judicial gymnastics. What's the difference? We are not staying the law, but we are staying the implementation of the law. What's the difference? Okay, forget about the difference. Even while you stay the implementation of a law, you have to mention the grounds. What are the grounds on the basis of which you have stayed the implementation of these laws? These grounds have not been mentioned. And it sets a terrible constitutional precedent which is bereft of any judgment. For example, Maratha reservation of Maharashtra was stayed by the court. But while staying the implementation of this Maratha quota, the court said, explained the reason why we are staying the implementation. The court said, there is a 50% limit. In Indrasani judgment, in Mandal case, we have imposed a limit that the reservation cannot exceed 50%. Since because of this Maratha reservation, this 50% cap has been breached, has been violated. On this ground, we are staying the implementation of the Maratha quota. So the courts, when they stay the implementation of the laws, they also divulge the reasons why, on what grounds we are staying the implementation of these laws. In this case, the Supreme Court did not say why. That's another problem. There is a bigger problem, and this is something hilarious. The Supreme Court said, farm laws we will stay, and what will happen because of that? It may assuage the hurt feelings of the farmers and encourage them to come to the negotiating table with confidence and good faith. At the face of it, this looks like very innocent statement by the Supreme Court. farmers are hurt because of these laws. If they are hurt, let's assuage their hurt by staying the implementation of these laws so that they can come on the negotiating table, so that there can be honest discussion between the government and the protesting farmers. But the problem is, this principle does not exist. Just because a particular law has hurt the sentiments of the people, you can't stay the implementation of these laws. Citizenship Amendment Act also hurt some people, you did not stay. The Jammu and Kashmir Reorganization Act also hurt some people, you did not stay. Similarly, these so-called love jihad laws also hurt the sentiments of some people, you did not stay. In fact, when the petitions were filed in the Supreme Court challenging the validity of these love jihad laws, Supreme Court issued notice to Uttar Pradesh and Uttarakhand state without staying the law. So in that case, also those laws were hurting the sentiments of people, you did not stay, but here these laws have hurt the sentiments of the farmers and you are staying these laws. It is a dangerous precedent which is bereft of any judgment. There is another problem. The Supreme Court said something terrible can happen at the protest site. There are elderly, there are children, there are women who are protesting, and it is very cold in Delhi right now. It becomes extremely cold during the dead of the night. We don't want any untoward incident to happen. We don't want blood on our hands. That is why we are trying very hard so that both the sides reach to some sort of an agreement and the protests disappear. When CAA was passed, when there was a violence on the campus of Jamia Millia Islamia, petitions were filed before the court. The court was asked, dear Supreme Court, please at least stay the implementation of this law. Otherwise, there will be bloodshed in Delhi. Supreme Court said, we will hear this petition. First, violence should stop. So in this case, court is saying we don't want blood on our hands. Just some time ago, the court said first violence should stop, then we will hear these petitions. There is something problematic. Something else. The Supreme Court said, while issuing this order, that let's have a 4-member committee which will mediate between the protesting farmers and the government of India. The court said we are not experts, neither on agriculture nor on economics. That is why we will set up a 4-member technical committee constituting experts in agriculture and economics to look into and to mediate between the farmers and the government. You're not experts? If you're not experts, then why did you say few years ago, women of all age groups may pray at Sabrimala? If you are not experts on economics and agriculture, you're also not experts on religion. Why is it that in 1954, you invented a doctrine called Doctrine of Essentiality, wherein you said, we will decide what is essential to a religion, what is not essential to a religion? Why is it that you declared that triple talaq or instant triple talaq is set aside? You are not experts on religion as well. But you were right in interfering in the Sabrimala case. You were right in declaring that instant triple talaq is set aside. Why? Because that is your job. That's your duty. You don't have to be an expert on agriculture and economics. You just have to be a judge to look at whether these laws are constitutional or unconstitutional. That's what critics say. And that is why they are criticizing the judgment, the order of the Supreme Court. And finally, some people allege that Supreme Court is also sexist. Why? The Supreme Court in this order also said that there are elderly and there are women who are protesting against these farm laws. Please ask them to go back. Let's not have elderly and women protesting against these farm laws because it is a period of extreme cold in Delhi. Is Supreme Court being sexist? Aren't women also farmers? The majority of the people working in the agricultural fields are women. So does that mean Supreme Court is saying that elderly and women, please go back, let's leave it to the men and the men will discuss and debate and decide whether protests will continue or not. So heavily, some sections of the society have been criticizing the Supreme Court for this order. Let's recap. 3 farm laws have been passed by the Parliament. Some people say these farm laws are for the benefit of the farmers, benefit for the agriculture, and they will herald a new dawn for the agricultural community. And that is how the income of the farmers is also going to drastically improve. And there are strong arguments in favor of these farm laws. Let's not deny that. But there are also arguments against these farm laws. As civil services aspirants, without taking a side, what you need to do, you need to look at what are the arguments in favor of these farm laws, what are the arguments against these farm laws, without taking any side. You also need to look at whether these farm laws are constitutional. And looking at these farm laws from one angle, they appear to be constitutional. Why? Because the Parliament resorted to entry 33 of the concurrent list, passed these farm laws. These laws are not unconstitutional. But then procedure was violated on this ground. These farm laws are unconstitutional. That's what the critics say. Then there are others who say that the Supreme Court order is problematic. One section of the society says the Supreme Court was right in staying the implementation of these laws, appointing a 4-member committee. But the other section of the society criticizes and heavily criticizes the Supreme Court for passing such an order, for staying the implementation of these laws without providing any reasons. So dispassionately, we have tried to address and understand both the viewpoints. And that is what was the subject matter for our discussion today. If you're liking these initiatives, press the like button, comment on these videos, and let us know which topic would you like us to discuss in the next Explained segment, next Friday, 8 p.m. Till then, have a great time. Thank you for being with us. All the best.